So let me ask, when a client or a senior hands you a brief, what's the very first thing you do? If your answer is, I start drafting immediately, you're already setting yourself up for mistakes. Handling a brief well is what separates a professional lawyer from a panicking one. Hi, I'm GTL. Welcome to my YouTube channel. Today we're going to be walking through the 5 first steps every lawyer should take when they receive a brief. Point number 1, read thoroughly. Do not rush. Many young lawyers skim through and then they start writing. That's a big mistake. Always read the brief slowly, alright? Then at least twice before touching your pen or laptop. Yes, like RPN, the man of God will say, repetition is the law of long-lasting retention. You have to look over and over for you to retain the fact and then be able to analyze the scenario so as to apply the laws that are related. Look for the client's main grievance when you skim through the timeline of events and what they actually want from the court, because you just can't start drafting without a goal in mind. That informs your goal. That informs the purpose of drafting. Step number 2, identify the issues in question. So now this is a time where you don't just get lost in the story, all right? You ask legal questions. What happened? What is this tenancy dispute about? The issue might be, was a valid tenancy notice served and what remedies are available? Learning to separate facts from legal issues is your biggest skill as a young lawyer. And I'll say that again. Learning to separate facts from the legal issues is your biggest skill as a lawyer, because you don't just apply the laws to general facts. You pinpoint the issues within. Alright, because that's where the law will gain its highest strength. The law is for the issues within, not just for the general fact. So identify the breach in question. Remember, it is only where there is a law an offense can be created. So the fact that your client is grieved does not justify that there is a law that should be used to make amends. Alright, what does the law say about that breach created? And the third step is to check the law and the authority. Remember the IRAC rule in our universities: issue, rule, application, and conclusion. You establish, first of all, the issue in question, then you bring the rules, the laws applicable, and then you apply it. That is the IRAC. The C is where you get to give your legal opinion. Just like that, you check the law and the authority. Open your law pavilion or textbooks or statutes, but I recommend law pavilion. Everything is there. The rules, the cases, recent judgments are there. So you look it up and you check what section of the law applies. What precedents guide this matter? Because for every matter there is a precedent. There is a case that has been heard in court that has similar facts, if not similar to the core. There are some similarities. There are some statements made by the judges. There is the ratio decidendi, the reason for the action. Those dictums made by the judges, they corroborate the law. So take up these precedents and apply them. Study them carefully to see which area you can adopt, where it can be lifted to be applied. I'm using in simple terms so you understand. What precedents guide this matter? Judges respect counsel who comes armed with authorities, not just their personal opinions, not their legal opinion. They want you armed with authority, sufficient authority. So when you're stating a point in court, you're telling them, this was the authority that said this, and it backs it up. For example, if it's a land matter, first authority that comes to mind is the Land Use Act or a recent ruling by the Supreme Court on a land issue. See that? Point number 4, review procedures and deadlines. Many young lawyers lose cases before they even begin, not because of the arguments, but because of their procedural errors. Did your client file within the limitation time? Is this matter one that requires pre-action notice? You have to take a stand, alright, and view what is necessary. Don't just go about acting, drafting. You have to wait. You ought to have a better idea over the matter. You have to take a standpoint, all right, and sort of look at the end from the beginning to see the procedures to follow, to see the necessary steps to take, the substantive part of the matter, of the issue. You have to weigh everything to be sure you are on track, all right? That way you start drafting your processes, but you are guided. Always review the procedure and the deadlines. Ensure you're not losing out on the procedures required. I've seen many cases where clients walk away without justice So always check procedural rules first. It saves a lot of embarrassment in court. Imagine a judge calling to tell you he's setting aside your case because you did not give the required notice to your opposing counsel. It's like that. It happens like that. So step number 5, prepare notes, strategize before drafting. Before you draft, write a 1-page outline, all right, covering the issues, the beliefs, and the supporting authorities. That way, when you start drafting processes, you're guided. You won't be copying precedents blindly. You know what you're going for. Do this and trust me, you're going to see great results in drafting. Clarify with your seniors or your client what exactly they want, all right? You're asking your seniors for guidance, and then you're asking your clients to be clear on what they want. So sometimes the relief they are asking for is unrealistic. Your job is to manage that, manage their expectations. You have to be able to manage the expectations of your clients. Sometimes what they want is beyond the bounds of law. You cannot give that to them. So you have to manage their expectation. I remember a young lawyer who drafted a whole originating summons without realizing that the matter was statute barred. And the case was struck out in less than 5 minutes. If he had checked the limitation law first, he would have saved everyone the embarrassment, he would have saved his time, and simply tell his clients that that matter has gone statute barred. It cannot be heard before the court because the time frame with which he would have brought the argument and the procedure was up. These are the things to properly look into before you start drafting. When next you receive a brief, read carefully, check out for the issues, the laws, the procedure, and then prepare the notes before drafting. Your drafting outline. I call it your drafting outline. These 5 steps to make you into a competent lawyer. So lawyers, what's the first thing you do when a brief lands on your desk? Share in the comment section. Let's sharpen each other.